this table. I'll consult all of you and do what is right and proper. But let me make it clear that will ensure that there's discipline in that sector. Thank you very much.
Thank you. It's now the turn of Honorable Governor Kwame Abuja.
Chairman, thank you very much. I want to take the opportunity to also congratulate my good friend, our principal voice on energy-related matters.
Mr. Chairman, I do not, and that will not be permitted by the Constitution of the Republic. In fact, that will be inhuman and degrading treatment of our citizens.
Minority Leader also has a follow-up, so you may wait for your second question.
Honorable Nominee, have you become aware of the establishment of the ORA?
Honorable Minority Leader, a follow-up question must relate to the preliminary questions or the substantive question asked. But this is completely unrelated to the substantive question asked. So hold it. When it comes to your turn, you can pose these questions. Honorable
Chairman, with respect, please hold your horses. Let me make a point. We are dealing with matters of public tribunal. We are talking about issues that go complementary, okay? As far as possible, from all that you've said. I am trying to appreciate the point you made in response to the question he asked, that would you set up a tribunal which would carry canes to be, chasing people here and there. You responded that no, because it will not be in accordance with law. Correct? In the same spirit, I am asking you that the ORA, that committee, which we've been told is to receive information from the public regarding supposed looting and all that. If you become aware of it, do you think that its establishment is in accordance with the Constitution?
Honorable Minority Leader, I believe the question asked relates substantially to Article 1261B. This oral that we are bringing in is not related to the establishment of the tribunal as stated in the NDC manifesto. So I reiterate the point that you can hold it when it gets to your turn. You ask a substantive question, but this cannot be accepted as a follow-up question. Thank you very much, Honorable Leader. Honorable Bafo, proceed with your second question.
Honorable Nominee.
Chairman.
So, Minority Leader, Chairman, I cannot ask a member to proceed with the question, and then you ask that he should hold on. This is unacceptable. It's completely unacceptable. So, Honorable Bafo, proceed to ask your second question.
Chairman, take it easy.
Would you want to forfeit asking your second question?
Chairman, take it easy. 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 The nominee, in response to a question as to whether there will be an establishment of a tribunal, which will carry canes to lash people, responded that that would be unconstitutional. I am premising my follow-up question on the constitutional issue he has raised. You may disagree with me, Chairman. We are being cooperative, but please, he has raised a constitutional matter that if he establishes a tribunal with canes lashing people for the purpose of ensuring justice, it will be unconstitutional. Now, it is in that spirit that I am asking him, because he has raised a constitutional matter, that there are things that if you do, it will be outside of the constitution, and he as AG won't do it. So I am asking whether or not he's become aware of the aura, and if he has become aware of the aura, its mandate is within the ambit of the Constitution because he has raised it. So it is flowing from the very answer he gave on the constitutionality of the functions of a publicly established body, such as a tribunal. So, Chairman, I do not see why we should be locking horns on this matter. But however, if you insist, I will yield to you for us to make progress. If you insist, I will yield to you for us to make progress.
Honourable members, I insist that the question is unrelated to the question posed to the nominee relating to the establishment of the tribunal as contained in the manifesto of the National Democratic Congress. Honourable Bafo, may you proceed to ask your second question.
Honourable nominee, the question was, what is it that the high courts, regular high courts, are not doing that you need the tribunals to cure? That, Honourable nominee, I didn't hear anything. But more importantly, on the question of the promise that you are not going to set up a tribunal that will cane people, Honourable nominee, are you aware that there is the criminal practice and procedure of this country is regulated by statute, and that statute does not include private citizens called ORA, gathering evidence which will be handed over to the Attorney General to prosecute? Are you aware that there's nothing like that in the criminal, in the statutes of this country? Are you aware? Yes or no?
Honourable members, I know the nominee is capable of answering the question. But in our Criminal and Other Offences Act, as well as the Procedural Act, committees are not stated. But Honourable nominee, may you proceed to answer the question.
Well, I'm sure the honourable member himself well knows that Act 30, the Criminal and Other Offences Procedure Act, does not create bodies, organizations, agencies, or entities that are mandated to operationalize criminal procedure. It merely lays out the procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, there is nothing about oral in in Act 30. Now, the question whether oral is legal has been raised, by various people within the media, right? Oral is the Operation Recover or Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then, let me hear from Honorable Ayerga.
Mr. Chair.
He's coming in on a point of information.
Mr. Chairman, if you open the Constitution to Article 41, Article 41 deals with duties of a citizen. Please, everybody, listen to this. Article 41 deals with duties of a citizen. 41F says one of the duties of every citizen of this country is to protect and preserve public property and expose and combat misuse and waste of public funds and property. So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Mr. Chair, my
Honourable members, to our guests, I will reiterate the fact that we do not clap in Parliament, but we rather say, yeah, yeah. Is that okay? Honourable Ayerga, you are even not supposed to react. So observe the proceedings in silence. Honourable Ayerga, we are grateful for the point of information.
Okay,
you want to ask a follow-up question?
Before my last main question.
You are permitted to ask a follow-up question.
Mr. Chair, it is very interesting to note that notwithstanding Article 41F, the Criminal Offences and Procedure Act, Act 30, provided or has made provision for investigations, arrest, and prosecution of criminal offences. And it still doesn't include oral or private individuals acting. But my follow-up is this. My follow-up is this. My follow-up is this.
What you've just said was a preliminary comment, but not a follow-up question.
Mr. Chair, I plead with you to indulge me in the interest of Ghana. Roxanne, you promised to protect.
Please go ahead with your last question.
Okay. So, in the year 2010, the NDC administration under Professor Mills commissioned the Constitution Review Commission that presented its report in the year 2012. for which a white paper was issued in June 2012. Hope you remember. Good. Now, you spoke extensively seeking to justify tribunals, the establishment of tribunals. At page 21 of the report of the Commission of Inquiry, of the white paper on the report of the Commission, Constitution Review Commission, at page 21, the white paper stated as follows: maintenance of regional tribunal in court structure. Government accepts the recommendation that regional tribunal be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman of the regional tribunal, if any, should be absorbed into the judiciary as high court judges. This is by an NDC government. The question is that when you have previously accepted the Commission's report to abolish the Commission of Inquiry, to abolish tribunals, and now you say you are bringing it back, is it not double speaking? Especially when you have also failed to provide before us what the High Court is not doing that you want to correct with the tribunal. Is it not double speaking without any justification? Later 2012, yes.
So what is the exact date on the report?
The report...
You are referring to the white paper?
I'm referring to the white paper.
The report of the Constitutional Review Commission?
I'm referring to the government white paper stating its position
Very well.
on the report.
Very well. Honorable Nominee, your response.
Yeah, thank you, Mr. Chairman. I'm very much aware of the position stated by the honorable member. I was very intimately involved in the work of the Fiajo Constitutional Review Commission, which was headed by my own good friend and former colleague, whose secretary was my own good friend and former colleague, the current dean of the University of Ghana Law School, Professor Raymond Atuguba. I am also keenly aware of the fact that the government white paper accepted to abolish the recommendation of the commission to abolish the regional tribunals. However, an American justice of the Supreme Court, a justice of the Supreme Court of the US, very famous, Oliver Wendell Holmes, he once said that the life of the law has not been logic, but experience. When experience has taught us that there are deficiencies in our justice system. In fact, when the honorable nominee was talking about the honorable member, I'm sorry, I have been here since 9:30, you have to forgive me. When the honorable member was talking about delays, he's a legal practitioner and he knows that the traditional court system is also plagued with a lot of delays. You also know that sometimes they disregard the fundamental human rights of citizens. During the tenure of your own government, Afoko, Gregory, when a court of law ordered that he should be granted bail, you still callously detained him, and he's in detention now. That's a violation of the right of Gregory Afoko to liberty. So these things occur whether you are dealing with the traditional court system or a tribunal system. Okay? The good thing is to have men and women of integrity who will administer the law or administer justice in accordance with law. And that is what we are seeking to do with the re-establishment of the public tribunals. I think that our experience has taught us that the participation of ordinary citizens in the justice system is a good thing. And that is why, having thought about it, we are re-establishing it. But of course, we are governed, as I said, by a constitution, and I believe that there will be limitations to the powers of the tribunal as far as respect for the rights of persons appearing before them is concerned.
Thank you very much. I recognize Honorable Roxanne Nelson Kwame Eche Davamapo for a supplementary question.
Chairman, thank you very much. Professor Ayine, you are welcome.
Thank you, Mr. Chair.
You taught me, and you taught me well, and I'm very happy that you got this nomination. Now, you're also my chairman of the Subsidiary Legislation Committee, and I second chair you. And I know the quality that you put into your work. So you also taught me legal system. So let me clarify this. Are you actually saying that you are going to establish or create these tribunal courts, or you are going to implement the law? Because Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act,
You don't have the floor.
he says,
You do not have the floor. Even at point of order, I need to give you the floor. Honorable Nominee, may you proceed to answer the question?
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC CRAP committee. So if you take the compendium, the green compendium, I think that was where it was done, and the idea was to take them out. In terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly, because the President has hit the road running, and we, his nominees and his appointees, are his supplementary wheels. We have to help him to run as fast as possible. So I will bring a bill that will comprehensively deal with the implementation of the letter and spirit of Article 142 of the Constitution. Thank you very much, Mr. Chairman.
Thank you very much. Yes, you want a point of order. is the point of order relating to the answer or the questions being asked?
Mr. Chair, both. It made reference
But
to
you know, under the rules, you cannot take a point of order on a question being asked.
Mr. Chair, on the answer. On the answer.
Now, tell me what exactly is the answer that you are taking the point of order on?
Mr.
And what
Chair,
is your point of order?
Very respectfully. The Courts Amendment Act of 2002 amended the Courts Act of 1993 to abolish the district and community tribunals. So the only tribunal which remains on our statute book is the regional tribunal, which the constitutional review, government has accepted the constitutional review committee's report to abolish. So that is the only tribunal which is on our statute book.
So how different is that from the answer provided by the nominee, that he doesn't have the Court Act here, but he believes of an attempt to take it off from the Court Act? So it's not different.
Mr. Chair, very respectfully, this is a committee of record, so it is important that records are set, so that listeners will know that it doesn't exist anymore.
Then pose a question is John Darko.
Thank you, Mr. Chairman. Honorable nominee, I'm sure you are aware of a company called Cassius Mining. That company obtained a grant of prospecting license from the Minister for Lands and Natural Resources sometime in 2016. Actually, 14 days after the Mahama administration had lost power. The company at the time did not comply with the prospecting license. And they had made an application for renewal of the prospecting license. Following that, Honorable nominee, you became the counsel for
Honorable Member,
Cassius Mining.
do you have the evidence that the company did not comply? And in any case, that particular company is not before us. So you know the rules relating to speaking about persons who are not before us and will not have the opportunity to defend themselves. So be guided.
Thank you, Mr. Chairman. So following that, Mr. Nominee, you became the counsel for Cassius Mining and made demands on the government for renewal of the company's prospecting license. In fact, Mr. Nominee, you, as a lawyer for the company, you wrote a letter dated 21st February 2020, attention the Chief Executive Officer of Minerals Commission. You stated variously, but in particular, clause 4 of your letter to the Chief Executive of the Minerals Commission, you stated that the fact that the two shareholders of the company prior convictions cannot vitiate the license, it is not a relevant consideration. You stated, Mr. Nominee, that it is spurious and disingenuous for you to suggest that the minister can, on this basis, refuse to grant the license renewal. But even if it were so, damages will still flow and the government of Ghana will remain liable. Mr. Nominee, it will interest you to know that about 2 weeks ago, this company, Cassius Mining, for which you were once their legal counsel, has filed an arbitration against the government of Ghana, claiming in excess of 440 million United States dollars at the London Center of International Arbitration. The Attorney General of the Republic of Ghana is supposed to defend the Republic against all claims, including one such as this. Now, You were once the lawyer of this company. You believed in their claim against the government of Ghana. Mr. Nominee, are you going to ensure that when the Republic goes to defend this claim, the Republic of Ghana will not be burdened with this $441 million? And I'm saying this because of the appearance of conflict of interest.
I recognize Honorable Kwame Abuja.
Leader, the procedures here will all encourage our first-timers to participate fully in this. Indeed, that is why our side and the side of the minority brought in first-time MPs. But in this committee, you can lay preamble to ask your question, but not to make, endless statements. And I sit here and I ask myself, when is the question going to come? So, Chairman, can you direct that it is not against the procedures here to lay a preamble, but that must be brief, then you go to your question. Because I get lost as to whether somebody is making a statement or asking a question.
You see, Chairman, people, Honorable Whip, people sit outside and sometimes they bash the members of the committee. Being outside and having the opportunity to ask the question are two different things. You now have the opportunity, pose the question, but I will allow the nominee to provide an answer.
Thank you, Mr. Chairman. Mr. Chairman, the honorable member is right. I have been instructed previously by Cassius Mining. I filed pleadings in the High Court in Bolgatanga together with my junior partner, Mr. Gorin Tamaklo. We litigated, various applications before the courts. I want to put it on record that I'm no longer Cassius Mining's lawyer. However, I'm keenly aware of the fact that the Constitution prohibits a situation where a public officer puts himself in a position where his private interest conflicts with the performance of his public duties. As Attorney General of the Republic, I will be the Republic's lawyer. As the Republic's lawyer, I am supposed to act in the best interest of the Republic, in accordance with the best traditions and ethics of the legal profession. I will not, in any manner whatsoever, compromise the interests of the Republic of Ghana. Honorable Member, if you care to know, and I'm sure you are very well aware, that I was Deputy Attorney General under the former Attorney General, Honorable Marietta Brew. And for 4 years, we handled that ministry in such a way that the US government described the Attorney General's office as a corruption-free zone. We handled the ministry in such a way.
You are not supposed to take part in the proceedings. So remain silent and observe the proceedings. You are only here to observe.
So, Mr. Chairman, when we were in office, you can go back and check the records. There was no single incident, except the Wyoming matter that came before we assumed office. There was no single incident of questionable judgment that's arising out of or in connection with the performance of the obligations of the Republic in any contract or legal transaction. So I can assure the House that I will take measures if they are before the London Court of International Arbitration. I'm quite familiar with that tribunal. I've appeared before that tribunal several times. And I can assure you that I will put in the measures that will ensure that the interest of the Republic is not compromised.
you very much.
To follow up, Mr. Chairman, with respect.
Yes, go ahead.
Mr. Nominee, do you believe in the propriety of their case against the Republic?
With all due respect, I believe you have indicated the matter is before the court. Is that not so?
Mr. Chair, I think
and he is no longer the lawyer for the company. So in vetting the nominee, you cannot be soliciting for his opinion on that particular matter. So ask another question.
Okay, no. I never said I don't have any.
Please, have you finished asking the question?
No, since you didn't allow him to answer that question, I'll move on to another one.
Well, I have the right, if I feel the question is soliciting the opinion of the nominee, I can overrule you.
Even if he can answer, Mr. Chairman, I understand.
The question is overruled. If you are done, let me give the opportunity to another person.
Mr. Chairman,
I believe you are done. I will then give the opportunity to Honorable Shaibu.
Mr. Chairman, with respect, I am not done.
Honorable Shaibu, you have the floor.
Mr. Chairman, with respect, I am not done.
Chairman, with all due respect, please allow him to conclude. Please.
Mr. Chairman, thank you very much for your understanding. Mr. Nominee, your firm is on record as having acted for a number of companies which have gone on to make huge claims against the government. In some of these cases, the companies were formed between the year 2013 to 2017. Your firm was the law firm which acted as lawyers for the firm, for the firm. At the same time, you were the Deputy Attorney General. After you left office, the companies proceeded to go on international arbitration against the Republic, claiming millions of dollars. We have an example in GPGC, which was the claimant in the Trafigura arbitration case. Mr. Nominee, your law firm's address, Ayine, Feli & Co., is
Honorable John Dako. The nominee told the whole world that he is mindful of the conflict of interest situation. When he was a Deputy Attorney General, nothing of that nature happened. He's now before us to be vetted for the position of the substantive Attorney General. Why do you keep on asking questions relating to his law firm?
Mr. Chairman, I think it's very important. The Honorable Nominee, which I know very well, is going to be the chief enforcer of our laws. And so, Mr. Chairman, and he's capable, I know him very capable of answering any question posed to him.
It is not the capability.
Mr. Chairman,
it's not the capability of answering the question, but we need to be guided by the rules. You know, the law firm Ayine and Associates is different from Honorable Dr. Akuditinga Ayine.
Yes. Yes. But
so
it doesn't mean that he cannot answer. When there is a semblance of conflict of interest, I think that it will be in his own interest to answer that question, to clear the minds of all of us.
Honorable members, do you have any further question?
Mr. Chairman,
I ask the nominee not to answer such a question. I will now give the floor.
Mr. Chairman, I think you have been unfair to me. Yes, Mr. Chairman, if you believe that, for instance, this question...
Did you say I'm being unfair to you?
Yes, Mr. Chairman, with respect.
Why do you say so?
Because, Mr. Chairman, you are not allowing me to ask the questions I'm supposed to ask.
But I have the right to overrule you.
We represent...
We are guided by rules.
And the people need...
But we are guided by rules.
The people must hear...
Are you aware we are guided by rules?
Yes, Mr. Chairman, but I don't...
You cannot even ask incriminating questions.
I don't think at this point I have violated any rules of this House. Mr. Chairman, I haven't...
Where lies the question of conflict of interest? When the nominee has already provided the answer.
Mr. Chairman.
Honorable John Dako, you are out of order. I give the floor to Ahmed Shaibu.
Order, Chairman.
I give the floor to Honorable Ahmed Shaibu.
Chairman, order. Chairman, I want to intervene.
We have Ahmed Shaibu and Muhammad Shaibu.
Chairman. Colleagues.
So, Honorable Minority Leader, you have the floor.
Chairman, before I go into colleagues, please, let's resolve matter. Chairman, I am making this point. If you check our rules book, you have the chairman of the committee and you have the vice chair, and you have the ranking and you have deputy ranking. In principle, what our standing orders is trying to say is that there is a presumption of a co-chairing of this exercise. To allow, otherwise, if you will never, you would always want to have your say, but you don't want others to speak. That is your problem, NDC. That is your problem. Yes, we don't. Okay, if that is what you want to do, you're right. No problem. You will listen to me, Chairman. You can't say out of. You can say you've said that to my members. If you now want to extend it to me that I'm out of order and order, let's have.
If the standing orders,
can the vice chair leave?
If the standing orders has.
Can I finish? Can I finish, my respected vice chair? Can I finish? Chairman, we are here. We are here to work as a team. The rule talks about the chair and vice chair. If this committee is to deal with a sole chair without anybody to work to express a view, it would have limited it to chairman and vice chair and nothing else. In Parliament, whenever there is a chair, there is a ranking. It is not to checkmate, but to work together and to express views of the House. When we try to put issues across, we have some of your senior colleagues who reach out quietly to say, oh, please, you are going too much. We listen to them. We want to work together. But Chairman, with the greatest respect, I have observed consistently the way you go at my members, especially the young ones, the new ones. It's not the right way. I've been quiet watching, and I'll just be pinching you, the Chairman. Please, you take it easy. Take it easy. But the way it is going, I think it is not too right. To the extent that, as your co-chair, and I want to state this on record, well, the standing, don't worry. If you give it a purposive interpretation, it will lead you to that conclusion. Please, let's understand each other. This vetting should have taken place tomorrow, all three of them. We mean well, and I want to state that on record. We mean well as a minority. We cooperated to have days, 21 days or 15 days notice to be waived so that you can form your government as quickly as possible. I am pleading with you, Chairman. I am pleading with you. I do not. Can I finish? No, I'm not done. I want to be Honorable Mahama Yerga. I need to be done. I would have to be done. I do not like this situation whereby your side is still behaving as though you are in the minority. You are not in the minority. You are now in government. You are now in government. Please, we mean well. It is the reason why we are here. Stop the approach you are adopting. I am pleading with you. I am humbly pleading with you, Chairman. We plead with you. The approach will not help all of us. The approach will not help all of us.
You see, honorable members, I will give the floor to...
Chairman, he did not finish. Please. No. Chairman. The gentleman, no, Chairman. No, he didn't finish. No. He had called somebody. Chairman, all my plea is... Chairman, I beg you, allow him. Chairman, please. Chairman, please.
You see, honorable members, we don't sit here to gag any member, but we rather give you directions. The fact that we are guiding and giving you directions as an honorable member of parliament, you should take a cue and proceed. If I want to apply the rules strictly, as the former First Deputy Speaker have been doing, what happened today, we may not be experiencing some of those things. According to him, you are asked to ask a question, you ask the question. But we have allowed you to run commentaries, sometimes to read write-ups before asking the question. So I would urge all of you, particularly the new members, to take guidance from the chair. We are here to guide you. We are to guide you. So if you still have one more question, you may proceed to ask the question. Come here, I beg you. I'll give you the floor after that.
Bro, continue. Honorable. Continue. Ignore him. Continue.
Oh. Hold on with your question. Let me give the floor to Honorable Kwame Agoja.
Chairman, you see, nothing happening today.
Please, let's have order. Order.
Chairman, what the minority leader said about NDC being intolerant or they have been more cooperative is totally untrue. Mr. Speaker, Mr. Chairman, we've had situation when the president nominated people on Friday and we came here on Saturday to fetch the people. No advertisement or anything. So what is the minority leader talking about? That they have been more cooperative than us? That is not true. What we are saying is that, yes, indeed, we've had first-timers in the House, indeed, in the chamber. We've seen first-timers from both sides walking across the maze because they were not yet gone through orientation. So when, unfortunately, they haven't gone through full orientation, they come to committee and instead of asking questions, coming to read statement, it is appropriate we put them right. That should not be a situation anybody could interpret to mean that somebody is being gagged. And let it be known, as a matter of fact, at the appointment committee, we never allow friends or non-members to ask questions. It's because we wanted to carry everybody along that we give them the opportunity. So, Chairman, I would encourage you once again, stick to the rules. When you give an opportunity to somebody to ask questions, let that person ask the question and let's move on. This endless rhetoric of trying to quote things and never relate it will not help anybody. Mr. Speaker, Mr. Chairman, let's make progress, but let everybody who gets opportunity ask the question and let answer the question. Chairman, I also noticed, anyway, you go.
Thank you very much, Honorable Namomo Latte.
Thank you, Mr. Speaker, Mr. Chairman, for indulging me. I am very much concerned about what is happening here. And in as much as we don't want it to look like newcomers are being gagged, I think that parliamentary practice and procedures transcends the presence of this parliament. If we want to do it, we have to do it right, because you'll be going out there meeting other parliaments. So in the name of supporting first-timers or newcomers, all of us are still learning. But if we refuse to learn the right way, we will go out there and embarrass not just ourselves, but the Parliament of Ghana. So I'll plead with us, in as much as we want everybody to have the freedom to express himself or herself, let us do it within the laws, so that when we go out there, we'll have the confidence to operate. Leadership will not be there all the time to protect us. Even leader might not be on the floor of Parliament every time we have to rise and talk. So if we don't learn it the right way, we are the ones who are going to suffer. So I'll plead with you, let's do it the right way. Thank you.
Thank you. Thank you very much. We've been patient the whole day. Sometimes you get up and put on the microphone without being given the floor. We've been tolerant. It doesn't happen anywhere that you get up and then you put on the microphone. Somebody is asking a question. Then you said you are on a point of order. How do you take point of order on a question being asked? Well, you said you have one question more. May you proceed to ask the question.
Mr. Chairman, thank you very much. I want to believe that everything is being done from a good place.
Can you proceed with your question? Can you proceed with your question?
Yes, leader, thank you. So, Honorable Nominee, my question is, have you filed your asset declaration?
He's asking whether you have filed for asset declaration.
Yes, I have. I'm always complying with asset declaration, the filing of asset declaration. I've done that. Not for 2025, but for the last parliament, I filed my asset declaration.
Which is 2020, ending 2024?
Yes.
But I don't think the committee has a copy or evidence of filing. When I'm looking at the Constitution, if you look at the Constitution, Article 286, yes.
If you have a follow-up, please go ahead with your question, the follow-up.
Before you come in to ask the question, I want us to be guided by the constitutional imperative in Article 78, which states that for you to qualify as a minister, you must qualify to be a member of Parliament. The nominee before us has just gone through election and was elected the 4th time as a member of Parliament and sworn in as a member of Parliament. So let us be guided by the constitutional imperative in Article 78 and 94.
All right, thank you, Mr. Chairman. So, Mr. Nominee, your law firm, that is Ayine, Feli & Co., is on record to have been used as a registered address for a company called GPGC. Now, my question is, did you advise on the agreement between GPGC and the government of Ghana, of which you were the Deputy Attorney General then, and which led to a judgment debt of $134 million against the state?
Okay. So, Mr. Chairman, it is important to set the record straight because this is a House of Record. This is a Committee of Record. I became Deputy Attorney General, I think, in April 2018. When I was nominated, because I did not have the right to practice, my firm, or the firm of lawyers to which I belonged, was being run by Dr. Abdul Basit Bamba. And when GPGC came into Ghana, he was a lawyer who was approached to help them navigate the process of company registration. And he was the one who registered the company for them. And he had the right to do so to earn a living. He wasn't banned from practicing because I was Deputy Attorney General. Subsequently, Dr. Abdul Basit Bamba left Ayine and Fele, now Ayine and Partners. And when he was leaving, because GPGC was his client, he took them along. Okay? At the time of their PPA, he was no longer a member of my law firm. And I had no dealings whatsoever with GPGC in my private capacity prior to being nominated and appointed Deputy Attorney General of the Republic. And my former boss, the Honorable Marietta Brew, was very gracious to me because I came from academia. And one of the things that, the subjects that I taught, and I'm sure you took my natural resources law course, I was the head of the natural resources law department that included, petroleum. So she, subject to reporting to her, I was in charge of the petroleum and energy aspects, of any transaction that came to the department. Yes, so I issued a legal opinion on GPGC, all right, which was, because the PPAs are standard, the provisions are standard. You can take any normal PPA, the variations are not many. So I issued a legal opinion for them. I mean, I signed it for and on behalf of the Attorney General. So technically speaking, it was Honorable Marietta Brew's opinion, not mine. But whatever the case, when the dispute started because of the actions and omissions of your government, I was no longer in office, and I never acted as a private legal practitioner in any of the disputes. Mr. Chairman, that's all I can say for now.
I believe you have exhausted your questions. It is now the turn of Jerry Ahmed Shaibu.
Mr. Chair, thank you very much. The name is Shaib, S-H-A-I-B, with all due deference. Dr. Ayine, congratulations.
Thank you.
Doc, in 2021, during the hearing of the election petition, you were cited by the Supreme Court of Ghana for scandalizing the court. The matter was referred to the General Legal Counsel. The matter is still pending. My view and my question is that, are you, with all due deference, not in the position to have the matter resolved before you take up this high office of Attorney General and Minister of Justice? Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Honourable Member, before you come in, the matter is pending quasi-judicial decision. I believe we have a lot of members of parliament who have been sworn in with the matter pending judicial decision. To what extent does a member's involvement in a pending lawsuit disqualify him from being a member of parliament, let alone a disciplinary proceedings against a member? So, with all due respect, we need to be fair to all manner of people, and we ask very fair questions to the nominees. So, ask another question with all due respect.
Mr. Chair, thank you very much. I'm not too sure if I can respond to your question before going to the other question.
See, that is why I've indicated that the practice in the House is that you are guided by the chair. You are guided by the speaker. So you take the guidance and proceed accordingly to ask another question.
Very well, Mr. Chair. I take a cue. Dr. Ayine.
Sometimes it may be coming from the clients. Sometimes it may be coming from the courts or tribunals that we appear before, and so on. Yes, so I have been frustrated before, but that is normal. It's part of, it's part of life.
So, have you ever felt disappointed in an outcome of a case, whereupon that led you into some public outbursts?
Mr. Chairman, I don't know what the honorable member is driving at, but I don't, if you realize, okay, I don't run public commentaries on cases that are handled. As a matter of, the practice and tradition of my firm, we don't run public commentary unless the matter is political in nature and there's a need for some clarification because of the politics inherent in the matter. But as far as my commercial practice is concerned, yes, sometimes I lose cases, but I don't run commentary on them publicly.
Chairman, please, I claim your attention for the specific language I'm using for my question. My question is, have you ever been disappointed in the outcome of a case, meaning a final judgment in a case you did, whereupon you made some public statement? I'm not talking about running commentaries on a case you do. I am asking whether you recall any public outburst emanating from a judgment in a case that you did.
Mr. Chairman, I cannot recollect. So if yeah, I cannot recollect.
Honorable Dominic Ayine, in the Woyome case, where my Lord Ajet Nassem presided, you, the media, reported you to have said that is the submission of no case, where the judge ruled in favor of Mr. Woyome. In other words, his application that there was no case to answer was upheld, and your opposition to that application was rejected by the court. The media reported you to have said that the judge had made up his mind even before the case. If that report by the media is correct, on hindsight, do you think that you were right?
Well, Honorable Minority Leader, the witness indicated clearly that he doesn't run commentary. He cannot remember But you keep on asking about. So the witness will want to answer. Proceed and answer.
Mr. Chairman. Counsel, hold on a second. Chairman, I've used the word plead with you for the umpteenth time. Chairman, please, stop it. Some of our colleagues are expecting a certain level of conduct from us. I beg of you, let him proceed. Let him proceed, please. Let him proceed.
Mr. Chairman, thank you very much. I think context is very important. Context is very important. I do recall that when the ruling on the submission of no case was granted in favor of Mr. Woyomi, I was not directly handling the matter. I was actually supervising the current DPP and a team of lawyers to handle the matter. But then the judge, in his ruling, took a swipe at the Attorney General. That is my boss. He took a swipe at the Attorney General because this was a case between the Republic and Mr. Woyomi. So he took a swipe at the Attorney General. We read the ruling in chambers. We wanted to ignore it, but then lawyers were called who were then running adverse commentary against us in the matter. And so we took a decision in chambers that we needed to respond and to explain. And Mr. Chairman, there's a lot that I know about a judge that you don't know. So don't open a Pandora's box.
Chairman.
Thank you very much.
Chairman. Of course, I recall former U.S. Defense Secretary Donald Rumsfeld come out with this saying that there are known unknowns and there are unknown knowns. I'm sure that is the area you're trying to venture into. However, the unknown knowns which you want to refer to are not a matter that the public became aware of because you did not want to put the unknown knowns out there. That is why you didn't put it out there. I am only interested in the fact that the ones that you decided to put out there. And that is where I seek to ask you a question on. You've explained that it was in context, and I think that's fair enough. I wouldn't belabor. But let's also move to another point. The Supreme Court. There came a time where the Supreme Court made certain pronouncements, which I'm sure you were not too pleased with said pronouncement, and that resulted in some comments by you, and the Supreme Court was not happy. And eventually, the gentleman in you, as we all know, you conceded and put matters to a peaceful rest. What have you to say to young practitioners who will be dissatisfied with Superior Court decisions, given your own experience in what happened?
Mr. Chairman, thank you very much for the question. Once I am approved and sworn in, I will be the leader of the bar. And I'll set a very good example. I think even in private practice, you would admit that I am an example. I've never been engaged in any unethical conduct in my practice. So I will lead by example, and that will be from day one. So I wouldn't encourage any young lawyer to, out of frustration, take the judiciary to the cleanest. Because remember that I am not only Attorney General, Principal Legal Advisor to the President, but I'm also the Minister of Justice. I will be the Minister of Justice, meaning that the justice sector will be under my ministry. That will be the principal, apart from the Attorney General's Department, to be the principal sector in terms of policy and in terms of law that I will be superintending. And so I would want to have, a very good relationship with the judiciary, a good and respectful relationship with the judiciary.
Chairman, we have become aware of an executive instrument dated 9th of January 2025. And this executive instrument takes its strength from Section 11.3 of PNDC Law 327. It lists a number of ministries. Conspicuously missing is the Ministry of National Security. Now, in the Securities and Intelligence Act, there is a provision for the creation of the Ministry of National Security. Going in as the Attorney General, would you advise the President to amend this EI to reflect this new enactment that Parliament has passed? Because it appears that His Excellency solely relied on the PNDC Law 327 without paying due attention to the Securities and Intelligence Act, which Parliament passed recently.
Thank you, Mr. Chairman. And I have, previously had to have, discussions on this matter. But in terms of the hierarchy of laws, of course, the Act supersedes the executive instrument. And once the Act provides for a Ministry of National Security, and the principle of law is that Parliament does not speak in vain. We will, take a second look at it and then advise the President accordingly.
Thank you very much.
Honorable colleague.
And you have a long way to go, Honorable Leader.
Chairman, kindly stop this act.
I'm just asking.
Chairman, kindly stop this act.
Because you
Chairman,
seems to be taking the whole day.
Chairman, kindly stop this act.
Well, honorable members, I think there should be a ceiling on a number of questions that the leadership is also supposed to ask, so that we don't go to town. We go straight to the point. So, at our meeting, we need to take a decision as to the number of questions that leaders are entitled to ask.
Chairman, indulge me. Chairman, indulge me. Chairman. Chairman. No, even listen. Chairman. Recognize me. Recognize me. Chairman.
Chairman. We should allow free flow of proceedings. Okay? I beg of you. Honorable nominee, in Article 181, 5 of the Constitution, that provision in the Constitution received some judicial pronouncement. The very first one, I believe, the Clomega case, Clomega versus the Ghana Port and Harbors, where the Supreme Court had an opportunity to make some pronouncement. I believe that the court made some consequential orders to the effect that Parliament would have to ensure certainty in that provision of the Constitution by enacting a law to regulate 1815. It's been long overdue. We don't have a law yet. In the Sebeyabwa case, the Supreme Court even distinguished the lawfare, made a clear path, and said that even in situations where the transactions involve state entities with its own board, it wouldn't be considered as part of 1815. However, they still felt that Parliament has failed in enacting a law to regulate 1815. Now you have the opportunity. Can you assure the country that
he has the opportunity, or is going to have the opportunity? Or if he gets the opportunity?
Yeah.
Chairman, I think this question on Article 181, I sought leave from the chairman.
And what about?
I sought leave.
In relation to what I am saying, that now you have the opportunity, or now you are going to have the opportunity.
In a very important matter.
Is it on that issue?
I'm bringing a very important matter to your attention. That the Speaker set up a committee on Article 181(5), and that report and bill is ready. That's for your information.
Very much. So, leader,
and Mr. Chairman,
your wedding, now you have the opportunity. Do you still stand by it?
Mr. Chairman,
now that he's going to be given the opportunity?
Yeah, just to add to what the Honorable Patrick Boma has
Honorable nominee, hold on a second. Let me handle the matter with the chairman. Chairman, let me flow, okay?
You have been flowing
Let me finish.
Your statement is as if he has been approved.
Chairman.
Now the Attorney General. Meanwhile,
Chairman.
We are in the vetting process.
Chairman, I'll go back to the question. Honorable nominee, now you have an opportunity back to the Attorney General's chambers. Will you assure us that steps will be taken to enact a law to regulate 1815?
Thank you, Mr. Chairman. Just to add to what the Honorable Patrick Boma has said in answer to your question, Mr. Speaker set up a committee. On the side of the then minority, I was a member with the Honorable Dr. Kaisel Atufosin, and then the Honorable Elizabeth Ofosajari. And we came up with a bill. I'm a co-author of that bill with the Honorable Joe Gatti. And the bill was supposed to be laid in Parliament before we rose. But because of certain developments that took place, the bill has not been laid. I'm very satisfied being an author of the bill. We took, the Honorable Patrick Boma and I took part. We even had a stakeholder consultation, and the bill is ready. So it was Parliament's bill and was being sponsored by the members of Parliament from both sides. If Mr. Speaker still has that intent, I will allow that process to flow to its logical conclusion. Otherwise, I will adopt it as Attorney General, and with the backing of the Minister of Finance, Dr. Atufosin, will bring the bill back to Parliament, and then it will start the process of first reading through to passage. So that is what I can assure the country.
Very well. So, Honorable Nominee, you have become aware of the aura. You've become aware of the aura.
Yes, Mr. Chairman.
In your view,
oral was an integral part of our campaign message.
Right.
And our campaign, I was a surrogate campaigner for His Excellency John Dramani Mahama, and he's committed to oral, and I'm committed to it as well.
Right. So, good. In your view, do you see this committee as a constitutionally empowered committee? You think that it has a constitutional backing or any statutory backing to have this committee in place?
Well, if by constitutional backing, there are two ways by which the Constitution would have backed oral. That is, if it was specifically stated in the Constitution, such as the Commission on Human Rights and Administrative Justice, which is not the case, or if the Constitution provided the framework, the constitutional framework for the establishment of a body called the Operation Recover or Loot. But I think I stated quite, clearly, and I don't know whether you were in the room when I gave the answer, that one of the fundamental principles of the Constitution is the principle of accountability. And oral is about exacting accountability. And I think that my colleague, senior colleague, and partner, the Honorable Mahama Yarga, added substantive, sense to what I did, the answer I gave, by making a reference to Article 41F of the Constitution, and the obligation on all citizens, to take steps, to protect public property and to avoid waste of public, funds. So I think that oral is not unconstitutional. Oral is not illegal. Just because it was not set up by an act of Parliament does not necessarily make it an illegal body. So it has constitutional backing in terms of the fundamental values of the Constitution.
Chairman.
Well, before you come in, I recognize Roxanne Dafamabo on point of information.
Chairman, thank you very much. Chairman, the minority leader in submitting just a minute or two ago in respect of the Act 1030. Act 1030 does not provide for the establishment of national security. It provides for the functions of the minister. That's what it provides. And so there are two markedly different issues.
Thank you very much for the information. Honorable
Chairman, I would want to beg my respected colleague to get the law, open the provision that he is relying on, upon which he disagrees with me. He should open the provision, because the Act provides for certain ministries and provides for minister responsible for national security, minister responsible for finance and all. If he's saying that there's no such provision, no, please. Honorable.
So Chairman, Honorable Member, I recognize Honorable Ayariga to read the act.
Chairman.
I recognize Honorable Ayariga to read the act.
Chairman.
Honorable Minority Leader, few minutes ago you said that he should read the act. And Honorable Ayariga quickly wants to read the provision. So why are you not
Chairman.
comfortable with the act being read? Honorable Ayariga, go ahead and read that.
Mr. Chairman, the act severally makes reference to a minister. And then it goes to the definition section, and then it says minister means the minister responsible for national security. So it could be any minister of the president that he has assigned responsibility for national security. It doesn't command the establishment or continuing existence of a ministry of national security. Even when the provision tries to define a ministry, assuming that a ministry is mentioned, it adds and says that ministry means ministry responsible for national security. It doesn't say ministry of national security, but the ministry that is responsible. So the president can assign responsibility for national security to the Interior Ministry, the Defense Ministry, or indeed the Ministry of Upper East. So that is the president's prerogative.
Thank you very much. I think this is a usual rendition in our laws that would define ministry or a minister to mean minister responsible. So if today the minister responsible for roads should be the minister responsible for transport, the designation will be made as such. So I do not think this is an issue that we should belabor. Yes. I mean, it is clear now. So, Leader, proceed.
Chairman, with the greatest respect, you are expressing an opinion. Don't say it is clear now. The interpretation column of Act 1030 provides for the definition of minister. I've been part of legislation, at least for the past 12 years. It provides minister means, it didn't say include. Minister means the minister responsible for national security. Then it goes on to say ministry means ministry responsible for national security. In all humility, and at the risk of sounding immodest, the arguments that it could be any ministry by the president, to say the least. Anyway, again, if you go to Section 11, Section 11 provides Ministerial Security Coordinating Committee, and it provides, without limiting Section 10, there shall be the Ministerial Security Coordinating Committee, which consists of the Minister responsible for national security, Minister responsible for foreign affairs, Minister responsible for defense, Minister responsible for the interior, Minister responsible for finance, Minister responsible for communication, and Attorney General. So the law is very clear, and it is not a matter of the president assigning interior minister to be responsible for national security. It is provided for that we would have a minister of interior, a minister of defense, a minister of national security. Is there? Mr. Chair.
Honourable members, you see, at a point, the rendition changed to minister responsible, not minister of, because of these issues of realignment. So if today a minister responsible for Greek is supposed to be in charge of the national security, he is the minister responsible for national security. That is the designation. That is the reason for changing the rendition. We could say simplicity that minister for national security, but we are saying minister responsible for national security. We've taken into consideration issues of realignment of this nature. That is why, because other than that, each time there is a change, you must come and amend the substantive law in consonance with the change that you have made. But once you say minister responsible, it is incumbent upon the president to dedicate that to a minister appointed by law. See, all the laws from 2020. I believe this is even a Cavendish drafting, of which I am part.
May I ask, whilst nobody intends to hold the hands of the minority leader, but we cannot also say that the space provided for the minority leader means that, I remember I sat here beside Honorable Atto-Forson. Honorable, the former chair would always insist, how many questions do you have? Honorable Atto-Forson will have to declare, I have this number of questions. Is it the case that the only way to satisfy the minority leader is to say that as long as he's got questions, he must continue, even if it's tomorrow, to be able to say that that is the only one? Chairman, I would suggest, at this point, Chairman, at this point, the minority leader had enough time to make his point. So I think you should be beginning to give an indication as to how far this is going to go.
Honorable Chief, I'll be magnanimous to ask him to ask 3 questions. Then we can bring proceedings to an end. So you may ask the first one.
Honorable Nominee, if I heard you correct, if I heard you right, it is your case that the establishment of the oral committee is legal.
Yes, Mr. Chairman, it is.
Now, you are aware, you are honorable chair, if you have been very calm managing, if there is an attempt to disrespect me and to create a problem, Chairman, stop.
Far from that, you are putting words into my mouth. I am not in any case
I have been very quiet and very
calm. But I think you are trying to be very abusive.
Chairman, stop it.
I'm not disrespecting you in any manner whatsoever. I am not in any manner disrespecting you. We've accorded you all the opportunities in this world. We have accommodated you. So how do you say I'm disrespecting you?
Can I respectfully go to outstanding orders? Order 2 and 7.
Honorable boy, you have the floor.
Chairman, been very patient. The Chairman, we in Parliament are guided by our standing orders. Order 2171 on the Appointment Committee. The Appointment Committee comprises the First Deputy Speaker as chairperson, the Minority Leader as ranking, and the Deputy Majority Leader as Vice Chairman, the Deputy Minority Leader as Deputy Ranking Member, and then he lists the following. There's only one chairman. Only one chairman. We don't have co-chair of this committee. And the rules of this house is that we allow the chairman to lead us and direct everybody so that we can have an orderly business. My respected Honorable Afenyo Marcus has chaired committees. And we've always deferred to him that allow all of us to basically do the work. It is as if he is not respecting the chair.
Exactly.
And it is completely not right, especially on an appointment committee where the whole public is looking at us. I think that where we are, the right honorable, my colleague, please, let's respect the chair. He will give you all the opportunity. But when the chair makes a determination, you will be the first to support him.
Honourable Member, your second question.
Chairman, with respect, I beg you. We've come very far with the nominee, and I think we don't want to end this day having vetted the finance minister designate, the energy minister designate, and our respected colleague in this kind of situation. I beg of you, Chairman, we've come very far. Please, let's give him the space to finish. He has guests from his constituency, chiefs. We don't want him to leave this room disappointed. We've come very far with him. Let's indulge the minority leader to end his question, please. I beg you. I know why I'm saying that. I beg you. I beg you. Let's give Kwame.
So we need to be guided. Minority leader, how many more questions do you have? I need some answer from him so that we can be guided regarding the number of questions that he has to ask. No, we cannot finish tomorrow. Well, he can say that we'll finish tomorrow. The whole world is watching us.
Yes, Honorable Chair, please. I think we've been on this committee, and we've had a case where Honorable Haruna Idrisu has been vetting and questioning until he's satisfied with it. Yes, even sometimes he starts with a warm-up and he goes, but please, I think where we are at the moment, let's try and indulge and then finish up with him. I'm sure he's almost at the end of it.
So we just need an indication from him. How many more questions does he have? Or how many more minutes does he want to be given so that he can finish up his question? Leader, how many more minutes do you want? Or how many more questions?
I think if you leave him, you will be able to wrap up. He's here. We are all here waiting.
Oh, leader, you have the opportunity to wrap up using the words of the deputy leader.
No, I said, you just leave him. Allow him
to wrap up.
Through the questions that you want.
No, the word I've heard is that he should wrap up. So
you
have the opportunity to wrap up.
On the other side, nobody asked any question. And he needs to also satisfy himself and make sure that the questions that were not asked are being asked at this point in time. That's how I feel it. Once you didn't ask questions, you can ask questions to that effect.
Chairman, thank you very much. Honorable nominee, you are aware as a legislator that when the former president, His Excellency Nana Addo Dankwa Akufo-Addo, in his fight against corruption, decided to set up an independent body, he had to come to Parliament to enact that law for the purposes of the office of the Special Prosecutor. You are aware of that?
Yes, I am, and I was, a key actor during the enactment of the OSP because of where I came from.
You were also a key advocate for the law to be enacted to enable the Office of Special Prosecutor have the legal powers to proceed with its work, correct?
I don't know what you mean by a key advocate. I took part in the lawmaking process. Go back to the Hansard. My initial position was that it was an unconstitutional body because it was, to me, violative of Article 88 of the Constitution, because we're taking the constitutional powers of the Attorney General and giving it to another person and seeking to say that the Attorney General that person should be autonomous or independent of the Attorney General. And I said, no, those prosecutorial powers inherently belong to the Attorney General, and no one can take them away and then say that the person should be, ring-fenced in such a way that that person, should not be controlled by the Attorney General. I made very forceful arguments to that effect, and that is how come that there were provisions, the independence provisions were watered down at my behest. And of course, I was just a lone ranger at the time, but I'm no longer a lone ranger. I'll take a look at the law again.
So now, in view of that reasoning, which you hold so fair, and if I may have to repeat, you're saying that the establishment of the Office of the Special Prosecutor took away the prosecutorial powers of the Attorney General. Now we have oral with investigative powers. Don't you think, in line with the same reasoning, that committee is taking away the investigative powers of IOCO and the police?
I am not aware that.
Honorable nominee, before you come in, you made reference to Article 88, particularly Article 88.3, that gives exclusive jurisdiction or power to the Attorney General to conduct criminal cases. And any other body that is conducting a criminal case is doing so on the authority of the Attorney General. Therefore, I recall that in the passage of the Special Prosecution Act, argument was canvassed to the effect that we cannot give the Special Prosecutor, by an act of Parliament, power to do prosecution. And this was heated to the extent that the Attorney General at that time agreed with our position. They used their numbers 169 against 106 to push the law, and when it gets to the third reading, the Attorney General then declined to come and move the motion for the third reading, leading to the passage of the law. But today, it's being stated that there was argument from the nominee to the effect that special prosecutors will have power to prosecute. The Constitution is very clear on power to prosecute, but not power to investigate.
Honorable nominee, my question to you is this. Here is a committee without any legal backing, of which you say and insist that it is legal. I'm asking you, this committee is out there saying it is investigating supposed looting. Now, we have state institutions with the mandate to investigate allegations of corruption, conflict of interest, and certain actions of public officials. Shraj is a typical example. We've had situations where members of the public have gone to Shraj on certain matters. We have the police. The police has various units that does investigations. We have IOCO. We established IOCO, Act 804. If you look at their mandate, they have all the powers. Are you saying that this committee does not conflict the work of these statutorily established state agencies?
Mr. Chairman, no.
Your answer.
No, it doesn't. And I'm not aware that oral has been, conferred with investigative powers. They are gathering information for purposes of determining, whether or not some wrongdoing has taken place by a higher body. I remember them saying that once the Attorney General takes office, they will hand over the information. It's like a whistleblower, coming to the Attorney General with information. There's nothing legally wrong with that. So I still stand by that.
Thank you very much. I don't know why oral is posing so much threats to some Ghanaians.
Honorable nominee, if I understood you correctly, is it your suggestion that upon taking office, ORA shall cease to be in operation? I just want clarity.
Honorable Leader, the nominee never said so. So I do not know the clarity that you are seeking from something that the nominee has never said.
Okay, no problem. Honorable nominee, since Chair says you never said so, let me now ask you.
And I did not say so.
That's okay. That's okay. No problem. That's all right. Honorable nominee, are you saying that because you believe that ORA has a legal backing, your office is going to continuously depend on ORA for the purposes of providing you with information for your prosecution?
Honorable Minority Leader, the nominee never said so. So you may ask another question.
Chairman, please, for the third time. Honorable nominee, as Attorney General and Minister of Justice, you will primarily rely on state agencies such as police, IOCO, and FIC for the purposes of building your case for prosecution, correct?
Well, the qualification primarily doesn't sit down well with me. Some of the institutions we mentioned have statutory power to conduct investigations that are restricted. So, for instance, if you take, IOCO, economic and organized crime, period, they can investigate anything relating to, say, murder or treason and so on, or other crimes, right? So their mandate, their investigative mandate is restricted to economic and organized crime. So they are creatures of statute, okay? The Attorney General will rely on any source of information, okay, that will lead to the detection of criminal offenses, whether relating to corruption, whether relating to looting of state property, and so on. Once that, gives us the basis to gather evidence of wrongdoing, we'll aggressively pursue it, and then it will serve as the basis of prosecution.
Thank you once again. Listening in silence.
Chairman.
Do you have any more questions?
Honorable nominee, thank you for the response to my earlier question. Now, you have indicated that the mandate of ORA is to gather information for the Attorney General. So, I want to ask you, as Attorney General and Minister of Justice, will you continue to depend on ORA within the period of your service to the states as Attorney General? I want to know from you.
Mr. Chairman, I think I have made it abundantly clear that I will depend on any reliable source of information relating to wrongdoing that will mandate that we investigate. And by the way, one of the new things, Mr. Chairman, one of the new things that I will be bringing to that department is setting up an in-house investigative unit.
Thank you very much. I recognize a supplementary question from the Chief Whip, Honorable Kwame, Governor Sakboja.
Honorable Dr. Ayine, will you say, or will you agree with me, that oral is in line with Article 41F, which says, the preamble says, the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen, in fact, not even oral alone. F, to protect and preserve public property and expose and combat misuse and waste of public funds and property. In this case, I cite an example of what oral put out, that an individual of this country was trying to take over land that doesn't belong to him. The individual came out through his lawyer to say it is not true. Yet oral put out details from lands registry showing that that individual was almost illegally or taking over land that doesn't belong to him or at a price that is not fit to be sold at that price. In your case, do you think oral has done this country good for that exercise, which is not illegal? Nobody was beaten, nothing was done to anybody, just that that piece of land has been saved for this country. Will you say that oral has done well as far as you are concerned?
Nominee, please answer the question.
Mr. Chairman, the honorable member has described aptly how citizens comply with Article 41F of the Constitution. Thank you.
Honorable Minority Leader.
Thank you, Chairman. good intervention by my respected colleague, Kwame Akpoja. A good constitutional exercise we are doing now. So, on the Article 41 that he has introduced, the 41F, Chairman, I would want to know from the nominee that upon reading of Article 41F, which was relied on by my respected colleague, would you say that the exercise of said duties is not done in accordance with law? Because he created the impression that it means that any citizen can get up in the name of protecting public property, go to an institution and start warning public servants, locking up offices. As we are experiencing, people are being chased out of their homes, people are being beaten, and he is on public television quoting the law and saying that Article 41F, and I'm reading it, is there to protect and preserve public property and expose and combat misuse and waste. Now, we are hearing and seeing on our TVs what is happening at public institutions, where civil servants are being locked up, people are being chased in their homes. Is this the interpretation given to the 41F, or side duties provided for in this particular provision is supposed to be exercised within the confines of the law?
Honorable nominee, before you come in to answer the question, you can profile your understanding of Article 41F of the Constitution of the Republic of Ghana. But there is no evidence before us that Oral has gone to lock people's offices, they've locked people's houses, or they've beaten people up. So I would even urge the Hansa Department to expunge that aspect of the question so that you can go ahead and tell us your understanding about Article 41F of the Constitution of the Republic of Ghana.
Chairman, with respect, nominee, Chairman, with respect, this particular question, I did not refer to ORA. Please, I did not refer to ORA. I did not anchor it on ORA. If I can repeat it, I did not.
Well, if your reference is not to oral, then we do not have evidence before us that such a thing has happened. And that is the more reason why that should be expunged from our record, so that the nominee will go ahead and then give us his knowledge about Article 41F of the 1992 Constitution of the Republic of Ghana, with due respect to my learned friend.
Okay, so then let me, just because for the purpose of clarity, let me now rephrase the question so that the nominee will not be in any form of confusion.
So that question is expunged.
That's okay.
You may go ahead and answer.
That's okay. That's okay. Honorable nominee, have you become aware of post-election violence by some Ghanaians? Have you become aware?
Nominee, are you aware?
I am not aware of any violence.
That's okay.
Yes.
That's okay. That's fair enough. Honorable nominee, have you become aware that some Ghanaian citizens have been going into public offices, locking up public offices? I would want to give you an example. Ghana Port and Harbour Authority.
Well, Honorable Minority Leader, is that not part of the violence that you refer to, that the nominee said he is not aware?
Chairman, I've been reminded over and over again that you are the chair. Please. I asked the first question of violence. He said he's not aware. That's fair enough. My second question is, has he become aware that some Ghanaian citizens have been marching up to certain public offices, locking up the offices, and I will give you the examples. Ghana Ports,
meaning they are peacefully locking those places, or is part of the violence that you are talking about?
Chairman, can I proceed with my question? At TDC, locking up the offices, at Bui, locking up offices, have you become aware of these actions?
Well, Nominee, are you aware?
Chairman, it hasn't come to my attention. That is true. On social media, I see reports, but I haven't read them.
Thank you very much. Any further question?
Mr. Chairman, to the nominee, should you become aware of the conduct of some of our citizens, the conduct of going to state institutions, threatening public servants and civil servants, locking their offices? Should you become aware as Attorney General, what would be your reaction by way of advice to the government?
To be honest with you, I would not want to comment on this because it will prejudge whatever steps I will be taking or may be taking in order to address the situation. Until I have the full complement of facts, I will not be able to proffer an opinion.
Thank you very much. But let me remind the entire nation that 2017, such a thing was complained about, and then chairman was heard saying that if people are protecting public property, what is wrong with it? MPP chairman, Freddie Blay, is on record. See? I can produce the record for you.
Chairman,
recently it was circulating.
Chairman, a moment ago, when I was asking a question, you asked me that since there's no evidence before us, you directed that that question should even be expunged. That was the position you took. I have asked a straight question. You are now introducing Freddie Blay, who is not here to defend himself and to say this and that. Chairman, in all humility, I believe that since you are calling on the Ghanaian public to watch proceedings, consistently since morning, there are members of the public behind each of the nominees who have gained notoriety for shouting and heckling as if they are part of the proceedings. You have had the cause to ask them to stop. They continue to do that. You see, let's be fair, because if something even happened yesterday, are we saying that we should continue to endorse it? I beg of you, we are a nation making progress in our governance at all levels. I would want to plead with you that withdraw or retract the mention of Honorable Fred Blake's name. If you think that you want to...
Honorable member.
Chairman, let me finish. You are the chair. You will have all the powers. I beg you, let me finish. I think that it is most unfair to Honorable Fred Blake, who is resting at home, to be mentioned here when there's no matter relating to him. I would humbly implore you to take his name out of this matter.
Honorable
if
member,
you think you still want to keep his name in, that is up to you.
Honorable Minority Leader, people are asking of the evidence. My source of the information is Star FM headline. I would therefore urge upon Honorable Ayariga to read it for the entire nation. And if you still want me to withdraw, after giving you the source of the information, then I will listen to you. Honorable Ayariga.
Star FM published this January 12, 2017. MPP members only protecting state facilities. Blake justifies takes over. And then it says the acting chairman of the New Patriotic Party, Freddie Blake, has defended the lawless and violent seizures and takeover of state facilities by some members of the party. According to Mr. Blake, not all the takeovers of state facility by MPP members must be condemned, since in some cases the supporters are only protecting government agencies. Should I continue? I can stop there.
Honorable Member, thank you very much. Okay, I recognize Honorable.
Yes, Chairman, not too long ago, the respected leader referred to some of our citizens sitting behind the nominee as foot soldiers who were brought here to make noise. I take an objection to that. Foot soldiers brought myself and the minority leader here. So their presence at vetting cannot be a nuisance. Secondly, he suggested that they have gained notoriety for making noise. I have been on this committee. Indeed, sometimes when nominees give answers, it generates spontaneous reaction from the back. They are not notorious. So may I also ask my respected colleague to probably rephrase the rendition that says that foot soldiers were brought here to misbehave, and also they have gained notoriety for doing something that they've been warned not to do. It is his choice to either oblige and do that, or decide that foot soldiers are not to be seen in Parliament. If that is what he means, I wouldn't mind my foot soldiers to be here because they are the ones who brought me here. So it's up to you.
Thank you very much. Once again, as a chairman of the committee, I will apologize to our dear guests for any comment in any manner whatsoever. So I sincerely apologize. Honorable Minority Leader.
Thank you, Chairman.
Are you done?
Yes. Chairman, I have my last set of questions for my respected colleague. That has to do with nomination to the Supreme Court of Ghana. Leonard, we, unfortunately, as a House, could not take the appointment committee report on two nominees of His Excellency the President. One, Professor Richard Frimpong-Opong, two, Justice Sophia Rosetta Oduokua-Benas. I know that whatever was pending before the 8th Parliament is not binding on the 9th Parliament. In any event, there is even a new president. Now, what is your own view regarding these two citizens of the land? The ordeal they've gone through and the fact that Parliament could not elevate them. Given the opportunity as an Attorney General to make an input in any nomination, any future nomination to the Supreme Court, would you consider making your views known on these two nominees to the appointing authority?
Honorable Minority Leader, you rightly stated the position that nomination during the tenure of office of the 8th Parliament lapsed by the 8th Parliament. And in the 9th Parliament, we have another executive president in whom the power to appoint is vested. The nominee before us doesn't have the power to appoint. And there is no law that states that he should make an input into the appointment of the Supreme Court judges. So I believe strongly, with all due respect to you, this is not a fair question to the nominee.
Chairman, please kindly allow the context of the question to proceed. I ask the nominee, in view of what happened, these are citizens of our country who were nominated, who went through the rigorous vetting of this committee. Now, there is a new government. There's a new parliament. I want to know from you, what would be your advice to Mr. President, if you have the opportunity, on these two individuals in any future nominations by His Excellency the President?
Thank you very much, Honorable Minority Leader. You know the nominee is designated for the position of Attorney General and Minister of Justice. He is supposed to advise the President on all civil and criminal matters. Legal matters, for that matter, must be by the advice of the Attorney General. But it is different from issues relating to appointment. And here we are asking the nominee his view, his opinion on some judges that were appointed by the previous government, which couldn't get through and the appointment lapsed. So let's allow the executive president to exercise the power vested in him by Article 58 of the Constitution of the Republic of Ghana. Thank you very much.
Very well. Honorable nominee, please, do you know Professor Richard Frimpong Opong? Do you know him?
Thank you very much, Mr. Chairman. Professor Frimpong Opong, just like my former students line up here all the way to Roxin Dafiamapo, is a former student of mine. I taught him at the then Faculty of Law, University of Ghana, and I know him very well, just like the same way I know Roxin Dafiamapo as my former student.
How do you know his practice of the law?
Mr. Chairman, I have no details of his practice of the law.
Very well. The question has been answered.
Should you be given an opportunity to recommend him for nomination to the Supreme Court of Ghana, will you willingly proceed to do that, knowing his record, his academic record, and his exploit in his chosen career?
Let's cross the bridge when we
Do you know his academic record?
Yes, I do, because I taught him, I graded his papers. You know, he was a first-class student. Actually, the two first-class students were himself and then the current OSP. So I know him very well. But I'm not ready to opine on whether or not I recommend him to President Mahama for appointment. That the prerogative of appointment is that of the President, not mine, as Attorney General.
Thank you.
So that is true. And you are not the one to do nominations. But my question is, in view of the fact that you know his academic records and you know his professional career, if you are given an opportunity to recommend him for nomination to the Supreme Court, would you be able to make that recommendation?
Thank you very much. The nominee has provided an answer that appointment is an exclusive preserve of the President, not his. I wonder if you have the opportunity, or he has the opportunity in law to be recommended.
Okay, Chairman, with respect, Chairman, with respect, if you pay attention to me, we will be done.
It's just suggesting that I wasn't paying attention to you.
Chairman, can I ask?
Are you suggesting I'm not paying attention to you?
Chairman, can I ask this question so that we can do what we're supposed to do?
Chairman, is disrespecting.
Chairman, can I ask the question?
Chairman, I'm not being disrespectful. I think the whole world knows we have done enough by giving opportunity to the minority leader. Chairman, I will request you close the meeting now. We have done enough. No one in this country will say that we haven't given enough opportunity to the minority leader. Enough is enough. Enough is enough, the Chairman. Nobody will say he's not been given opportunity. It's enough.
Chairman, thank you very much. Chairman, my question is not about the nominee appointing a Supreme Court judge. My question is not about the nominee appointing. I asked the question that the honorable nominee, in view of the fact that you've said on record that you know the academic pursuits of the Professor Opon, and you know his professional exploit.
Mr. Chairman, I never said I knew his professional exploit. I said I taught him, I know his academic record. And on the record, it is not only academic qualification that presidents take into account in appointing, judges. So, and I'm not the appointing authority. I'm not going to sit here and opine as to whether or not, if I were hypothetically the appointing authority, I would have appointed him to the Supreme Court. And when you asked me the question, I said, if the president asked me, his opinion, let's cross the bridge when we get there. Because there will be a number of variables that the president would have taken into account in requesting my opinion. So I don't think that it is fair to me to want me to be answering hypothetical questions about future appointments.
Okay, my final question to you.
All members, let's allow. Let's take him by his words. Final question.
Honorable nominee, you are now going to practice before our court as the first gentleman of the bar. Do you have confidence in the justice delivery infrastructure of our country.
Mr. Chairman, I do have confidence, but there's room for improvement. It is not perfect.
Thank you very much.
Chairman, I would want to thank you. Chairman, I would want to thank you and thank the nominee for taking time to answer all necessary questions. I wish you well and pray that you are able to discharge your duties as Attorney General and Minister of Justice for the good of our country. And again, I pray that the opportunity given you to serve as Attorney General will be another opportunity for you, with all your years of experience in academia, in parliament, and in private practice, to enrich rule of law. Thank you very much indeed, and God bless you.
Thank you, Mr. Chairman.
Thank you very much, Minority Leader and members. Honourable members, before discharging the nominee, let me bring it to the floor that the actual communication to Parliament signed by His Excellency, the President of the Republic of Ghana, His Excellency John Dramani Mahama, to the Speaker of Parliament has come to our notice. So all along, we were relying on a document that has been corrected, and the correct version has been brought to our notice, and the Minority Leader has perused same, and I believe he is satisfied with the content. You know, he indicated that he wants the right thing to be done at the time that we have no knowledge that it has already been done. So I believe he's seen a copy of it, that we have now seen the correct document. Honourable members, may I use the opportunity to congratulate the nominee and thank him sincerely for attending upon the committee, and to say that you will hear from the committee. You are accordingly discharged.
Thank you, Mr. Chairman.
Honourable members, only the members should stay. Members of the committee, not friends, should stay.
Chairman, let me just acknowledge. Honourable nominee.
Oh.
Honourable nominee.
Oh.
Honourable nominee.
You cannot be seen to be asking questions.
I'm not asking.
Conclusion.
We are not there on the letter. On the letter. Let me.
Honourable nominee, you are discharged. Vetting for today is over.